is Jimmy Miller, who's the founder of our firm and has practiced locally for 32 years. Jim holds a Juris Doctorate degree from the Claude W. Petit College of Law. Recognized as a leader in his field, Jim Miller is a VA accredited attorney and a member of a number of professional organizations, including law. But the main thing is, he's been my personal attorney for the last 15 years or so, as well as one of the owners of Sunshine State Title and Miller Legal. So without further ado, I'd like to welcome them up here. Please put your hands up.
What Jeff didn't tell you is that for 30 years I was the attorney for most of the boards of realtors here in Palm Beach County. For a decade, I had the largest law firm defending real estate agents in the state of Florida. We got between 100 and 200 cases a month where realtors were sued. We tried cases from Pensacola to Key West. I don't think there's a large real estate operation in the state of Florida that we haven't represented at one time or another. Now, in 1997, I was selected by the insurance industry as the best attorney in the United States at resolving real estate cases. So, I was the original developer of the affiliated business arrangement that a lot of people have today, where title companies are owned in conjunction with real estate agents or real estate brokerage companies. We did the first Chicago title, was my joint venture partner. That system is throughout the United States. We got the first one to get it through the HUD approval process. In 1 year, I had an office in Destin, Florida for a number of years, and in 1 year up there, we did $500 million in development in less than 12 months. So what you're going to see is that if it deals with dirt, I probably dealt with it at one stage or another. At this point, I've done over 45,000 closings in Palm Beach County alone, between myself and my 27 title companies. So what we're here to talk to you about today, we're not selling you anything. We don't need you to buy any of our programs. What we want to do is bring some issues that we run into on a daily basis so that you have an understanding of them. Now, I have the pleasure of having my son practice law with me. He's been out there for over 5 years as my law partner. He has a degree from FAU in real estate and finance. The year he graduated, he won the award for the real estate degree at FAU before deciding to go on to law school and practice. So he's got a pretty good background. I stopped being the board attorneys when I took over a real estate company. I had 11 offices. The company was called Castles by the Sea. We had offices from Las Olas in the south all the way up to Melbourne in the north. We had 11 offices, 190 agents. Our average sale was $1.4 million, and we did somewhere around $400 million a year in sales. So, it was a conflict of interest to represent one client, a real estate company, when you're the Board of Realtors attorney, so I had to give that up. So what we'd like to do with you today, though, is I'd like to sort of set the stage for you. So I'm going to be, this is the investor side of me. So you can call me Donald Dollars. And the part of Freddie the Flipper will be played by my son. And we'll kind of set the stage. This is very common. You people are all going to have seen this or have been in it, and you may not know what you were really in. Freddie?
Donald, you're not going to believe this. I found the best deal.
Really? Well, tell me about it.
It's a 3-2. I got it under contract for $150. I need to put $50,000 into it. Comps say $5.
Really?
I think I can get it done in 6 weeks too.
6 weeks? How do you know you got a team that's going to do it in 6 weeks?
They don't call me Freddie Flipper for nothing, Donald. I'm the best. My guys, 6 weeks, no permits, no problems.
Wow. What do you want from me?
We just need a little bit of cash.
Ah, the golden rule, huh? Well, let's say if I put the cash up, what do I get back out of this arrangement?
50-50 on the profits.
50-50 on the
50-50.
How much money are you going to need?
I'm going to need 150 on the purchase and 50 on the rehab.
6 weeks?
6 weeks,
What do you think it's going to sell for?
$500.
$500,000.
$500,000. We'll be splitting up $300,000 here 6 weeks from now.
You sure?
I'm sure. It's always on time, always on the budget.
Are you going to give me a mortgage, or how do I got to make sure I get paid if something happens to you?
Well, I was at this real estate conference recently, and there was this guy, Ben Mala. He was very charismatic, and he told me we should form an LLC.
An LLC?
LLC. I'm totally sure how it works, but I know that I can go on the internet in about 5 minutes. There's this website called Sunbiz. I think it's something with the state of Florida Division of Corporations. And for $125, we can have a business.
And we're going to own this business together?
50-50.
Well, who's going to make the decisions on all these construction questions?
I'll handle everything day to day. All you need to do is put up your money today, and 6 weeks from now, you'll be getting another check.
So you're going to be the manager of this LLC?
Exactly.
Sounds pretty good. You heard Ben talk about having an LLC?
Yep.
So I'm going to turn it over to Evan to kind of talk to you about what goes on with an LLC before we come back and finish up this arrangement. How many of you out there have had this kind of a conversation with a potential investor? Some of you? How many of you have used the LLC out there in Florida to do their business with? Everybody knows that there's 4 different versions of ways of doing business in Florida. You can either be a sole proprietor, which puts all your assets at risk if one goes down. You can be a partnership, where you're responsible for everything your partner does. You can be a corporation, which separates your ownership from your personal assets, or you can use an LLC. So, Evan?
So an LLC like he said, it's a limited liability company. Basically, it's a blend of a corporation and a partnership. By default, if you are working in conjunction with another person under the law, you're in a partnership. Some people don't realize that a sole proprietorship just means you're operating in your own name. If you do nothing else, you can even get a DBA for a sole proprietorship. You can have what looks like a business, but it's really all on you and all the liabilities on you. A partnership is really the default entity for multiple parties. We get together, we do this deal, we don't form any entities, we don't understand anything about that or care about our liability because we just don't know. Then we're a partnership. And the issue with a partnership, of course, like he said, by default you're a general partnership, which means one partner is liable for all the actions of the other partners. Because in this case it could be one person, it could be 4 or 5 people. A limited liability company is kind of a blend of a partnership and a corporation, where we're limiting your liability, right? You've got nothing at risk other than what you put into the LLC, but at the same time taxing you in a way that's similar to a partnership. Because as if you were here this morning, you might have heard talking about corporations, and by default, a corporation is subject to corporate income tax. You might hear about the corporate income tax rate in the news. Unless you have a C corporation, it probably doesn't affect you much, because a lot of people who have corporations, in fact, elect to be taxed like a partnership, which is called an S corporation. It gets a little bit technical, but an S corporation has a number of restrictions that an LLC doesn't have. They're taxed similarly, but an S corporation can't have more than 50 owners, it can't have foreigners as owners, and it has some restrictions on the transfer of the stock. So the default entity that most people use, most investors use LLCs these days. And with an LLC, okay, we've decided to form it. Now we've got a few options. The first option we want to think about is who's going to be in charge of making the decisions on a daily basis, the manager, so to speak. And there's really 2 structures that you can choose from. One of which is a situation in which it's called member-managed LLC. And in that situation, all of the members of the LLC have the decision-making authority. The other alternative is a manager managed LLC where, let's say in our example, if one of the members is making all the decisions on a daily basis, that person would be serving as a manager of the LLC in addition to being a member. So Donald over here doesn't need to be making decisions on a daily basis. He doesn't want to be involved, right? He wants to write the check and pick the check up. That's the dream, right? You cut the check and you get a big one back in a couple of weeks. Of course, that decision, people often make it arbitrarily, thinking, that doesn't matter, I'm filling out this form on Sundays. There's all these little 3-letter abbreviations like MGR. They don't know what they mean. AMBR, which means authorized member. It's just a member who's authorized to act. And they think that those distinctions are arbitrary, but that can have, as we're going to see later in our presentation, significant impact on your responsibilities and kind of obligations to the company. So once you've made that decision, like for example, in our situation, it would make sense to have a manager-managed LLC with the manager being Freddie Flipper. He's going to be the one handling everything. Donald's interest is really to secure his share of the property, and he would be receiving that 50% interest. The second decision we go to is, in this case, it's not functionally a decision, but it often is for people. It's, are we going to be a multi-member LLC or a single-member LLC? If I'm doing this deal on my own, this is Freddie Flipper using his own money, I might be tempted to form a single-member LLC. Because as a single-member LLC, I'm not required to get a new tax identification number. I don't have to do an LLC tax return. I have the option of just putting all that on my normal 1040. If I'm already doing it, it doesn't cost me a dime. I think I want to be in charge. It's my money, no problem. In Florida, there is one issue with that. There was a Florida Supreme Court decision back in 2011 called the Olmstead decision. And what that said is, in the event of an outside lawsuit, let's say I'm Freddie Flipper, I did this deal entirely without Donald, and it's all me. I'm a single member LLC, I have Freddie Flipper LLC, and I get into an auto accident, and someone sues me. And they go, wow, this Freddie Flipper owns this LLC, he's got 15 properties in it, because I didn't want to pay the fee to set up individual LLCs, so I dumped them all into one. Because that's what people do, right? And then from there, that in the case of a single member LLC, with that lawsuit, they have the ability not only to get what's called a charging order, which lets them kind of step into my economic shoes, it allows them to take over the rights to any distributions I would receive. So say, for example, I get sued for $1 million, they've got this huge judgment against me, and I'm going to be receiving a $100,000 distribution at the end of the year from the manager of the LLC, right, who is me. They can, in the event of a single member LLC, they can take that distribution. It's the same way it works with a multi-member LLC. They can take that distribution. The difference being, with a single member LLC, they don't just get the ability to take my distributions, they can actually foreclose out my property. So they can not only step into my economic shoes, but they can make decisions for the company, and I lose complete control over that asset. Whereas if I had another member in my LLC, they could only get the rights to my distributions. And as you know with LLCs, like in a situation like this, we have some flexibility with our ability to distribute, to make this a very unattractive LLC for a creditor. We're not going to distribute this year. I'm going to take a management fee for legitimately managing the LLC, and they don't have any rights to that. That's not a distribution of profits, that's my salary. So there's some kind of games that can get played there to make a multi-member LLC look very unattractive to any kind of person who has a judgment against you. Whereas with a single member LLC, the Florida Supreme Court says, no, we're going to allow them not only to take your distributions, but to come in and make decisions about whether to sell the property and to liquidate everything. So it's often beneficial, even in the situation in which I'm handling everything myself and I want to be on it by myself, to add a second person. The issue being that there is no threshold of how much I have to give that second person. Is 0.1% enough? Is 1% enough? Can I give my spouse 1% of my 1% interest in my LLC and that be enough? The Florida courts are kind of still trying to work that out. Some people are going with 5% to be safe. Some people are depending on your risk profile, going with 0.1%. 99.9% to me, 0.1% to this person, because by definition we now have multiple members. In our situation with me and Donald, we're obviously going, like we said, with a manager-managed LLC. And at the same time, we're obviously going to be a multi-member LLC because we have multiple members. We're both going to have an interest in the property. I'm not just going to be a manager, I'm going to be an owner in it as well. The kind of third option you have when forming these LLCs is, okay, what state am I going to set this up in? Just because we're doing business in Florida, we both live in Florida, we both declare Florida our homestead, doesn't mean we're obligated to form a Florida LLC. You'll hear, typically when you hear people talk about what we call foreign LLCs, it just means a non-Florida LLC. You're talking about one of three other states: Wyoming, Nevada, and Delaware. Those are kind of the jurisdictions in which people typically form LLCs if they're not using their home state. Wyoming was the first state to have an LLC statute, so they were kind of first to the game and they've marketed heavily. Nevada's claim to fame is that they don't have a information sharing agreement with the IRS. Although as an attorney, I will never tell you to lie to the IRS and hope that Nevada doesn't tell them. But that they put it in their marketing materials. And the Delaware, of course, has a long history with corporations and has tried to transition that to an LLC business. When you go to one of these states, generally the reasons people give for doing so is they're thinking greater privacy, greater asset protection. Like I said, Florida has this decision about single-member LLCs. Even who doesn't have that decision, Wyoming, Nevada, or Delaware. That's a Florida-specific rule about single-member LLCs. So in the event, say, I don't want to give anyone 0.1%, I don't want to have to worry about these things. I can always choose to set one up in one of these jurisdictions and not have to deal with that. Because yes, do you have a question?
I do. I don't know if you're getting to it, but...
No, go ahead.
So if you become so you're operating in Florida,
Yep.
right? So you would want to be protected by operating in Florida. From a parent-child relationship and the protection you get, let's say you open up your LLC in Florida and you create the parent to be, and then after the fact, let's say 2020 you created in Florida, 2021 you created in Delaware, and then you basically say that Delaware is the parent of the Florida LLC.
Mhm.
Are you still protected, and is that still good?
You would still be protected from the single-member rule in that situation, yes.
Okay, so it doesn't have to be sequential. The parent can come after the child.
Correct. The other thing, so the privacy and the kind of asset, with the exception of the single-member LLC situation, the kind of privacy aspect of this is really a farce. Because in order for if your LLC is transacting business in the state of Florida, you're required, or else you'll face a fine and you lose some rights. You won't have the right to file a lawsuit in Florida until to establish here. You have to register with the state of Florida as a foreign entity, and that's going to involve paying those fees, paying potentially a fine, which could be several $1,000s for failing to register. So you are going to have to list that information on SunBiz in order to transact business in Florida anyway.
But if the company itself, since inception, right, was created in Florida, because you're going to operate in Florida, but you want the anonymity, right, protection of Delaware, because we all know that they sue a lot of people here in Florida.
They do.
And there's a lot of lawsuits all the time, right? So you then create the parent in Delaware, and what you want is the anonymity that you get from Delaware, but you still continue to operate legally with your LLC in Florida.
If you're still operating it as a Florida LLC, though, you don't have the...
I don't have that protection.
It gets a little more complex because you can stack entities. You can have, let's say, an LLC managed by another LLC, and I mean, we've seen it 5 or 6 levels deep. Where, because what you're really looking for in the case of lawsuit protection is, okay, I'm an attorney. I get a client in that wants to sue this person, and people go to systems like LexisNexis and do these kind of basic asset searches. And the question is, will it show up in one of those? Because if it gets to the point of where someone was injured on the property and I'm coming after you, I'm going to subpoena all those records anyway. You're going to have to tell me about Delaware, and you're going to have to disclose exactly what you own and what its value is. So you're kind of trying to prevent the lawsuit, thinking, oh, well, I've seen these. All the guys on the billboards are taking contingency fee cases, and they're not going to do it unless they think there's something there. That's really what you're trying to avoid, and you can do that by stacking layers, because the systems just aren't complex enough. Yeah, go ahead.
Is it fair to understand what you're trying to say? Other than the single member LLC, you know, that's sort of ruling that you said, other than that, is there other benefit and the privacy, so like you said, it's kind of important. Other than that, is there any other benefits doing it in those 3 states? If you, for example, if I'm not going to do a single, I'm willing to do a multi-member, then there's no reason to do it in Delaware or
It's often depending on how cost sensitive you are, there are a couple of other benefits that are kind of more technical, but you're going to have to end up paying a registered agent in whatever one of those states you use. They all have, go online, form a Wyoming LLC. You have to hire a registered agent who is someone who basically receives service in the case you get sued. You're going to have to pay that person. You're going to have to pay Wyoming, say, for example, and you're going to have to pay the state of Florida. So there's no significant benefit. No state has LLC laws that are so different from the other. There's something called the Uniform LLC Submission Act, and basically it's what most of the states have adopted. It's relatively uniform.
Okay, so if you purchase a property and you put it onto your LLC,
Mhm.
are you protected if you have a trustee
So
where they can't find your asset?
if you mean, are you talking about like in the example of a land trust or something?
Yes, a land trust, yes.
It would be, yes, the attorney would not be able to find it.
So would that be
Obviously, in case I'm already suing you, I'm going to get a copy of the trust. It's going to tell me that you own it.
No, I had a property and I put it on my LLC and I had a trustee and I put it into a land trust. Was I not protected?
So you're protected from someone trying to do an asset search,
So
but
let's say they want to sue me.
But when I take your deposition, you're going to have to tell me the truth.
Yeah.
And if you don't, and I prove that you did not tell me the truth, I now have a criminal act in which I can prosecute you. And so that's the problem with that whole scenario is, yeah, if they don't go beyond that and they check the records, they don't find you. But if they bring you in for a deposition, which most plaintiffs' lawyers are going to do, they're going to ask you those questions, and they're going to ask you about some of the assets you own. And if you lie to them, and I can substantiate that, then you've got a problem.
it's really about lawsuit avoidance. Any person, I will say this as a blanket statement, and it holds true in 100% of situations, who tells you that there's a strategy that will 100% protect you from liability and lawsuit is lying. There is no way to have, actually there's one exception. If you are a sovereign nation,
Native American.
and this applies when
Some
you're
people
on a-
call them Seminoles
Yeah.
or Miccosukees in Florida.
And you don't realize this, when you go to the Hard Rock, anything that happens there, you cannot sue them. They have no liability. They are a separate nation, separate from the United States,
The
that has its
unconquered.
own sovereign immunity. So anything that happens there, yeah, it's something that people don't realize. But anyone that tells you that put things in an LLC and a trust and you don't have to worry about it, what you're really trying to do is, I want to limit my liability to this property. Because I own, we own 20 properties here. I don't want to contaminate. I want to keep each one as separate as possible.
So what we're talking about doing really is setting up an LLC. So the first thing you're going to do is, people think that just because they can go on SunViz, put in their credit card, pay $125, spend 5 minutes typing in those figures, that they now have created an LLC. And for practical purposes, they have. but they often, even if they're doing it together, don't end up following up with that.
And that brings us into part two of our situation.
Situation here.
We're now 12 weeks later because everyone that tells you it's 6 weeks, it's 12 weeks is really the goal.
Here we go. He told me 6 weeks, but 12 weeks. How do we do, Freddie?
I've got a contract, $500,000.
Wow. What did it cost us to do the renovations?
$50,000. We're looking at a $300,000 profit.
Just like you said, huh?
50.
Boy, this is great.
To you, 150 to me.
Geez, I got 150 on a $200,000 investment in 12 weeks. I'm kind of liking this. I'm the old guy. I don't want to have to do the work, but I got the bucks. But I've also got the scars on my back and the scars on my wallet from all that experience that we had. So, what's our next deal, Freddie?
Next deal? So at that real estate conference, I met this guy, Jeff Green. He was great. And I found a deal and I actually partnered with him.
What?
Yeah.
What?
Well,
why didn't you bring it back to me?
You're great, Donald, but I was getting 60-40 split over here, and I'm the 60.
You didn't come back to me with a business opportunity?
Our deal was done, Donald. I made $150,000 for you in 12 weeks, but Jeff's offering a better partnership over here, and we've got a deal we're doing.
I don't think it's going to work that way. I didn't get these scars for nothing. I got to tell you, Freddie, you stole a business opportunity from me. And you need to learn a lesson, and you need to learn the law. And the law is, that 60% you think you're going to get from this Jeff Green dude? 30% of it's going in my pocket.
Oh, how do you figure? I don't need your money on this one, Donald. I'm over here with Jeff now.
You stole a business opportunity, and we're 50-50 partners. Now, what does our operating agreement say about all this?
Operating agreement?
Operating agreement.
I don't operate on anything.
Well, after we formed this entity, this LLC thing, I went and talked to my lawyer, and he told me that in Florida, you don't have to have an operating agreement. But he also told me that if you don't have an operating agreement, you default to the statutes in Florida, which is Chapter 605 of the Florida statutes. And that means that you, Freddie, who operated as a manager of this, owe a fiduciary duty to the other shareholders, which is me. And since we're 50-50 partners, that 60-30 business opportunity that you think you got, 30% of it's coming in my pocket without me putting up a dime. How do you like that?
That sounds like duty, all right.
Yes, sir. Those scars were earned, both on my back and in my wallet. So, folks, this is what happens in real life. This comes in more times than I can tell you. Because what ends up happening is you get into these relationships, you're out, you're talking to your friend, you're all in real estate, you're talking real estate, just like Ben says, just like Max said. You get enthused about it. You're talking to your friends. Hey, I got a great deal. I found this property. I need some cash. It may not be a 50-50 scenario. So you go on Sunbiz, you form this great, LLC, and you don't do anything else. You buy the property in the name of the LLC. It sells, that's fine. You got to understand that in Florida, if you don't have an operating agreement, then you have loyalty obligations and fiduciary obligations back and forth between the partners. I like to think of it, and I use the analogy of a marriage. Okay? A lot of us in here have been married. Some of us have had training marriages and, now have a good one. But in any event, having an affair outside of that marriage, can you do that and not get divorced? In most cases, no. You might be able to if you agreed at the beginning to have an open marriage. And that's something you agree. But in business, we don't want to just verbally agree. We want to write it down. And we do that by putting in an operating agreement that says, look, if I get a business opportunity, I'm free to go deal with somebody else, or you're free to go deal with somebody else. Or we write in there that we're going to put it up. Sometimes it may not be the 50-50 split. It may be a different split where you set forth a procedure. Any opportunities are going to be come in to the group. You have 5 days to make a decision on whether you want to go forward with it. And if you decide you don't want to go forward with it, I have the opportunity to go forward with it on my own. So it's a way of dealing with those issues. Because otherwise what we end up with is if Freddie over here doesn't want to give me my 30%, what happens? I go back to that lawyer and I can get a large retainer bill from that lawyer to start this suit. I'm going to get my 30%, and I'm going to probably get my attorney's fees in addition, and I may even get the assets that are in that. So one of the key things with setting up this is, while it's not a legal requirement in Florida to turn around and have an operating agreement, you are an absolute fool for going into an LLC if you don't have one. One of the things you want to do is, even if you have a single member LLC, you go, well, I really don't need it because it's only me. I can't sue myself for making a bad deal. Well, sometimes I wish I could. Might make more in a lawsuit than I would of a deal. But what it does do is it helps to establish and separate that LLC and its assets from my other assets. In corporations, we call it piercing the corporate veil. If you don't follow the statutory requirements and fulfill those obligations and commitments that the statute sets forth, I can pierce that corporation, and your separation of ownership of that asset and your other assets are merged. The same thing can happen with an LLC. So one of the ways of showing that you follow that is by having an operating agreement. And that operating agreement is going to set forth all the rights, the liabilities, everything that needs to happen. It's the second step you need to go through. Now, in most states, and it varies a little bit, you have the obligation of good faith. You're operating for the best interest, and a lot of times the interest of a single member is not the same as the interest of the entity itself. We went into this as a business venture on this one property, but the idea is the venture wants to continue on. It doesn't necessarily want to just stop with that one property. So what he thinks is best for Freddie is not necessarily best for Donald. So there can be a distinction in what those intentions are and what their goals are. So what we try and do with an operating agreement is put that in. Now we also then can define, and some states do this. In Florida we had a shift a couple of years ago where we used to have a statute that said these things are your fiduciary obligations. And those were sort of the threshold questions. 2 years ago our state said, you know what? And some court decisions came along. Those are not going to be exclusive items. They're going to be sort of informational. We think those are the ones, but they aren't the sole things. A breach of a fiduciary obligation or a breach of loyalty is whatever the judge or jury decides in that particular case. So it makes it much more difficult to deal with. And so some people got real smart, They hire their lawyers. They go, I'm going to have you sign a waiver agreement that waives the obligation for those fiduciary duties. Unfortunately, in most states, those waivers are worthless because they will not allow you to waive all of those rights that you've come along with and have that obligation of commitment to your partner. So in the same way that a marriage needs to be written, it needs to be written here. Yes, sir.
The question that I have is, let's say for that example, you give an item example, but does it work, or is it out of line to think that you did this LLC so you could get the money from him and for protection for each side,
right?
And then you sold it, you kept your deal, you sold it, and for $500,000 you gave him his money back. At that moment, would you close the LLC? Is there such a thing as closing the LLC?
So you could, but again, you don't have an operating agreement that's going to tell the time of when that's going to be closed. So we default to the statute. And the statute says basically that every year that corporation, that LLC continues on. So
part of that, let's say, that operating agreement could be this is an LLC for the sole purpose of.
Yes.
Absolutely, but
You
that's
could-
why you want it written down and agreed to with everybody at the beginning.
You could specifically say, this entity is for the purpose of flipping 123 Main Street and will dissolve immediately upon sale, and no problem.
But it's gotta be in writing so we can protect.
Got to be in writing or you default to the statute. And a lot of times people will name, it's real easy. It's hard to get names sometimes. We all want to put acronyms. But it's a lot, I would say the most common name for an LLC is the address of the property. I got 128 Okeechobee Boulevard and LLC. And then I may have 129 Okeechobee Boulevard LLC. So I separate them out. And that's an easy way of doing it. Yes, ma'am. Yes, question? Yes, sir.
So also in the operating agreement, wouldn't you also add this LLC is for the purpose of flipping 123 Main Street and it's 50-50 between Freddie and Don?
You could, but it needs to be in that operating agreement. Whatever you're going to agree to, just like I was talking about with an open marriage, you better have that signed off, because I'm going to guarantee you when you start that affair, your spouse is not going to say, oh yeah, I agree to that. So it's the same thing with this operating agreement. Anything you want to do that varies from the norm needs to be in writing, signed by all parties. Because I'll give you an example. I'm litigating right now in one of these cases, because typically what happens to us is relationships like this blow up, and then both of them go to their lawyers. And then the lawyer goes, okay, we can deal with this. I know I can get this money for you if, in fact, we have to go to trial. But I need a retainer. And the retainer is going to be somewhere from $7,000 to $20,000. I'm litigating a case just like this, where a partner thought that he was a minority partner shareholder, and he thought that, he had a better relationship with the main client of the business. So he went and started his own company, unbeknownst to the other. And then suddenly came in on a Monday, and all the employees are now hired by his new LLC, and the customer is now using the new company to do work. Well, we've already spent almost $1 million in attorney's fees between the two law firms on that issue alone. It gets expensive, and in this case it will end up being worth it, but it's going to be a problem. At the end, the other side is going to lose on that one because of what they did. They had no operating agreement. The operating agreement had been drafted, but the leaving partner kept telling the other partner, oh, my lawyer's reviewing it. My lawyer's reviewing it. Well, at the same time he was telling him his lawyer was reviewing it and hadn't approved it, he was taking action to form this new company. So this is the normal circumstance that we run into with a lot of different investors. And they don't realize that just because Freddie and Donald did their deal, that doesn't mean that Freddie gets to go do a deal with anybody else he wants, just like that marriage situation. Because business divorces are just as expensive, not quite as emotionally charged, but just as expensive as divorces themselves are. Yes, ma'am.
Do you have to, in regards to the operating agreement, you sign it, you're good to it, do you have to register it anywhere, or is it in your laptop?
You should you don't have to, but you got to keep it in the records of the entity itself. And my recommendation has always been that just like we have a corporate book where every year we have our annual meeting, you have a LLC book, and in that is a record of all the documents, the original certification, a copy of the documents which entail the operating agreement. And just when you have these issues come up, you keep minutes of that and you put records in it. Freddie brought me a deal and I signed off on it. We're not going to do it in this corporation. We both sign off on it and keep it in that book, just to keep it safe. Yes, sir.
From your experience, would the two parties in the situation, the scenario you described, have brought their own attorneys and had them sit down together to create this operating agreement, or is it as simple as we agree on these 3-4 points, let's just sign off on it and it's done?
I would say that the normal circumstances is just like a marriage. When you're in that honeymoon stage, nobody worries about getting separate lawyers unless they're going to do a prenup. And when that prenup comes in, then they both lawyer up. But in this case, most times you just have to have somebody that talks about those points, to ask both of what do you want to do, and you reach agreement, and then you just reduce that to a written document that both sign.
So no lawyers involved.
So it could be with the lawyers, it doesn't have to be. Yes, sir.
Me? I just want to know then, should we or have an E&O insurance on every LLC that we open?
Well, E&O insurance isn't going to cover you for this type of a situation.
No?
This is internal. An E&O is more if there's an error or an omission that occurred in the drafting of the document itself. But the fact that there's not one and you go under the statute, it won't give you that kind of coverage.
So
it
for
wouldn't
a
help you.
case like yours there, because the two
example.
of you, who would you get insurance from? Because if you're going to get...
You're not going to, in most cases, you're probably going to have to go to Lloyd's of London to find anybody that would even try and incorporate that.
Fundamentally, I'm Freddie, and I breach my duty to act on your behalf. No one's going to insure the fact that I'm not going to screw Donald over, for lack of a better term.
So is it always personal money then? I mean, it's coming out of your...
It would
Could
be, like in that case, he can take his split of my kind of future gains, right? Because I stole this opportunity from our LLC and started a new one. He can go after that new one and take my rights in it, fundamentally.
But he can't go in after any of your personal things then?
No, not unless I did something beyond the kind of scope that was contemplated, like something willfully.
In this particular case, though, I could, because if he breached this fiduciary obligation, he made a conscious decision to do that. So it's a personal liability. It doesn't just stop at the corporation or the LLC. It passes to any other assets that he may own, and would be able to go in that direction. So it doesn't give that type of priority. Yes, ma'am.
Will this apply to any ventures that Freddie wants to, like, if he wants to go and open up a construction company?
Well, he might
Or is only
it doesn't necessarily apply to other ventures, like, if he went into a different type of business, he opens a contracting company, maybe not. But if he's doing the same thing that we formed this to do, it's going to be regulated. But they're all case specific. Yes, sir.
So just to be clear, should all these issues be addressed in the operating agreements to minimize the gray areas?
Exactly.
Yes.
That's all you're trying to do
The
is.
operating agreement try to
Yeah.
It's not-
identify a lot of these issues.
You're
so
trying to define what we've already kind of implicitly know. We all know we're doing one deal together, right? We're not going into business together for the next 100 years. So put that in writing.
Payoffs, the distribution. put it all
Exactly.
down to
Because what
minimize
we assume
confusion.
that the other party knows changes when they sue you. Right? Oh, no, I didn't know that this was just for that deal. I thought we were going to be partners for the rest of our
I
lives.
did more work.
Yeah. Right here.
So 50/50. The question is, the first part of the question is, does Hugh have the fiduciary responsibility? He's the member. He doesn't have that fiduciary responsibility. Is he under those same obligations if he goes and does a deal with someone else? Part of the
No.
question.
Very good point.
The other part of the question is, when you do a 50/50, who is able to make decisions? If he wants to make a decision and you don't agree with it because he's the manager, does he have the ability to override your 50%?
No, he does
Two
not.
questions there.
No, he does not. In most cases, it's the majority rules. It may be in a 50/50 if you're deadlocked. A lot of times you have to go to court and seek dissolution at that time, and either party could do that, almost like a partition action.
50/50 is frequently a
So in
problem.
that case, would it be legally smart to do, even if you're trying to do a 50/50, do a 51/49?
Yeah.
Is that-
Exactly.
Yep.
Don't you
Or you
have-
may put a third person in there that controls the swing votes.
And a quick question.
Wait, the second part.
And your second part of his question is go ahead, I'll let you go.
Well, no, he's right. We addressed the 50/50, and you're right. If the manager has, and this is why that distinction when you fill out that form is important, the manager has these fiduciary duties to the entity. Just because you're a member does not mean you have those duties. Right? Donald can go do other deals.
He can do another deal.
He can do another deal without me. The problem is we're really wearing two hats. We're both members, but I'm also saying I'm in charge of making business decisions for this. He's not.
So you can choose to open a bank account, or you can choose to buy another property for the entity without his agreement.
I can go to Jeff Green and cut a deal today. Or I'll go with his partner John and cut a deal
But your
today.
manager, he can make a decision that affects you as well. He can decide he's buying this other property.
Yes.
He's
correct.
going to make a deal with Jeff Green, and you're going to get he's made that decision, and you can say, I don't want to do that.
Right.
But he's made that.
By default, the manager has the decision-making ability.
Okay, thank you.
He's got his, his interest is protected. He's like a shareholder, basically. I'm CEO.
But he has to, you made the decision, he's going along with it. He doesn't get an option.
So folks,
Basically.
the key to all this really is, and we're going to have to cut it off just because we've got some other things. We'll be around. But the key to this is, the old saying is, I've got to inspect what I expect. In this case, you've got to reduce it to writing and make sure everybody agrees on it from day one. We certainly encourage people to use LLCs. We certainly encourage you to do it with an informed decision. And that is critical to avoid those legals. It's not so much about how much you get to make. It's about how much you get to keep. And, you heard Ben up here. We're lawyers. We pick your bones. We pick your wallets. And that's true. So when you run across these issues, you know where to come. But you can go wherever you need to. But go see a lawyer. And you heard Ben up here also say, I've got a lawyer on my team. We were talking about out there before he started speaking earlier today and last night. He goes, I'm on the phone with my lawyer 10 times a day, minimum. You can't do this and grow it big without a good team. And if you don't have a good accountant and a good lawyer involved in your process, you are an accident waiting to happen, because I can promise you at some point during this whole process there will be things that will come up that you will be sued for. I'm going to give you one example before I leave you today. Some of you may have heard this before. Because I did all this insurance defense work for real estate agents, you think that I deal with dirt issues, broken air conditioning kind of roof problems, easement problems, encroachments, bad refrigerators. I've got to tell you that my most interesting case in my career was trying to establish the value of an orgasm. Yeah, I'm defending a real estate agent. Now, she had sold a house to a woman on Jupiter Island. Multi-million-dollar house. The lot next door, Dan Marino at that time was supposed to build the house next door. So this woman that bought the house paid millions of dollars for it. The sellers had 2 golden retrievers. So occasionally when they're running the beach, wherever, they would pick up some fleas, and there'd be fleas in the house. So when they sold the house, they used a chemical called Dursband, which we can all go to Home Depot on the way out of here and buy some. It's a pretty common chemical. And they sprayed the house so she would not have a flea infestation when she took over the house. Now this gal was pretty good looking, 35 years old, a couple of $1 million in the bank, bought this house. She sued the sellers and the realtors and said, had I known that this chemical had been used, this insecticide, in the house, I wouldn't have bought it. And then she went on to, through the process, we took her deposition. Well, what type of injury did you incur as a result of the exposure? And she tells us that heretofore she had an insatiable appetite for men and sex. And as a result of this exposure, she no longer craved either. So she would get very mad because that put her whole sexual history into contention. Because now I got to decide whether I've really reduced it or I've improved it. So we'd start asking the questions, and she would just call us the Antichrist and get up and walk out, and we'd go to court. The judge goes, if you're asking for damages for that, counselor, you got to go back. So we went through that whole thing. She must have found out that we had to hire a chemist to evaluate whether Dursband could cause this to people. We had to hire we hired an investigator, and we found out that she was visiting the construction site next door to her house that Dan Marino was supposed to be building. It turned out he didn't. They flipped it before it got done. But and she was actually having some pretty good times, because we get her into deposition, and this is how we get to the value of an orgasm. She's 35 years old. She now testifies that her appetite for sex has returned, but her ability to achieve climax has not. So you want a tough job, try and figure out what the value of that orgasm is and how many times a sexual addict would crave it in her life expectancy from 37 to the 84 years old at that time for a life expectancy of a single woman. You know.
Is that ongoing?
We ended up settling the case. Well, we got dismissed out, but the week before we went to trial, She's gone through 5 attorneys. We're taking her last deposition. She had not been employed. Are you employed? Yes, I'm employed. Where are you working? I'm working for a phone service. Turned out she was pretending to be an Oriental on a sex line and being paid for it, and her attorney then dismissed it as to the real estate broker. But if you think that, truth is truly stranger than fiction, these things do happen. There's all kinds of things that come up in real estate. You think we only deal with dirt, and you think in your deals you're not going to have some problems. You may have them. So with that, I wish that we meet only in closings and never in court.
So the easiest way to contact these gentlemen is sunshinestatetitle.net. Do you have any other contact information?
The table right outside the door.
The table right outside the door. Or sunshinestatetitle.net. Thank you, guys.